This is Jen, the Liberty Lion, and I want to just point something out real quick on abstracts. So this is a speech from Mr. Davis in 1841. He's talking about public lands in this speech, but he's using an example here about how we speak and how we say something was said that wasn't exactly said that way, and how you're held accountable for what you say depending on how you say it. And I'm going to make my point here, but this is a really good example, I think, of how, well, a couple of different things of how you're held accountable if you say something was exactly this way or exactly that way, and how you're sort of not held accountable when you say it was kind of like this, something like this happened. And it was really just an excuse for the judge's attorney, whoever, to get what they wanted and have this, I guess, this case dismissed was the real excuse. But what they did was they took something that was supposed to be a concrete statement where the witness had switched it and then he couldn't remember which way it was, and they used that as his flaw. So they took it as, in quotes, this is exactly what was said. So the witness said, this is exactly what was said, but then later said, no, this is exactly what was said, which was different. And so when you say things in quotes and you say it was exactly like this, you're held accountable for what was exactly said. But when you say it was kind of like this or kind of like that, it's less accountable in the eyes of the law. So he says, this is an example that he's using that I picked out of this paper to lead you into abstract. A man named McCarty was brought before a magistrate for an assault. And the witness, to prove it, passed through a long, direct examination, and in it stated that the complainant had said to McCarty in the course of their dispute, quote, "McCarty, come out here," end quote. He was subjected to a long, rigid cross-examination, and the only difference that could be made in his story was that in narrating the transaction over the second time, he used the expression, quote, "Come out here, McCarty," quote, instead of the one he had first repeated. The counsel for the accused, having no other flaw to pick in his testimony, strongly urged this discrepancy as destroying the whole story. Whereupon the justice, a worthy son of the Emerald Isle, and with the ambition of his countrymen, not to say that a judge unwilling to appear less sagacious than the lawyers before him, says sternly to the witness, quote, "Now, witness, tell me precisely, did he say, quote, 'Come out here, McCarty,' end quote, or, quote, 'McCarty, come out here,' end quote, for it makes, you will perceive, a material difference in the eye of the law." I was working with the military. One of the things that was taught to me when writing logs is that because the log books are considered legal documents submissible in court as evidence, that the way you write in the log should be, instead of being factual, should be more abstract. So instead of saying, John Doe said this, quote, and then what he says in quotes, and or they did this, or they did that, or at this time they did this, and then they said that, that you would say things like, to the effect that, or it appears as though, it seems that it is as if it is similar to, or was similar to, I have this one in here twice. It is like, or it was like. So you're using these abstract words where you're not really saying a whole lot of anything at all. You're just making general statements that then if somebody tries to prove that you were wrong, that you didn't say that, or that person didn't say it exactly that way, that you're not held accountable for saying that they did. And so it's kind of sort of a little game that's being played, that if you speak in abstract, you're not held accountable for what you say because it's just your opinion or your belief about something. But if you say something that's like a fact, that you're then held accountable to it in the eyes of the law. So then I was wondering, well, I wonder how many times the government uses abstracts in its titles and its laws. So I use the example as if. So it was as if he was doing this, or it was as if he was saying that, because now it's just your opinion. So we go to the United States Code, Office of the Law Revision Council, United States Code, and we look up as if as our search phrase, and we get 3,776 results. So it's interesting that the federal government feels as though they can use abstracts in their laws, because then they're not really held accountable to the things that they say, right? Because they're saying, well, we believe it's this way, we believe it's that way, it's as if this or it's as if that. Then they're not really saying anything. It's all just abstract. It's all opinion. It's all nothing. It's not anything concrete. To act as though, to act as if something is something else. And I wonder if this may be one of the reasons why it's so difficult for people to understand how to follow the laws, because the laws are not written as factual statements, but they're written more as though they were just some general abstract things written down on paper that when you go to try to figure out what it is it's saying, it's just your opinion on what it's saying and not an actual fact of what it's saying. So there's an article out there called Statutes with Multiple Personality Disorders. So statutes with multiple personality disorders. And it does go into some of this stuff, abstracts, and how laws are written by Congress in very general terms, and then they're allowed to be interpreted by the various departments using those laws. And then if the interpretation is a bad interpretation, then it goes to court, and then it has to be heard in court, and then the court decides whether or not it was a good law. So all of this is sort of, I think to an extent, it creates a mad world. It creates a mad country for us because it's filled with things that are not concrete, not factual, not scientific. They're hard to understand because just like it's hard for you to know what someone else is thinking, you interpret it because your only recourse is to try to understand based on your own ability to understand, based on your own reality, based on your own experiences. And each person has different experiences than other people. And because of that, you interpret it one way, I interpret it a different way, somebody else interprets it another way. And so there's no real interpretation until you get to court and then the judge decides. And it's really not fair to have to go to court to decide what you should do now. And then by the time you get there, everything's changed. So if you look at some of these codes, this is the laws in effect on November 11th, 2022. So they update and change these laws, these titles regularly, and it's really hard to keep track of them. And not only do a lot of them not make sense because they're written with a lot of abstracts in them, they're interpreted in a variety of ways, but then also on top of that, they're constantly being updated, changed and updated, changed to reflect any new laws that are put out. And for this reason, it's very difficult for people to project or to formulate a plan on what to do in the future. And this is another thing that can drive people insane. Maybe not on an extreme scale, but to an extent, it drives people mad because they can't predict the future. They can't predict what their actions should be tomorrow. And if you're running a business or a family or what have you, you need to be able to predict your finances tomorrow and 10 years and 20 years and 40 and 60 years from now, so that you can plan for whatever kind of future you want to have for yourself and your family. With things constantly changing and no real idea of what something is and what something isn't, it's hard to predict the future, which really drives us just insane and crazy, and has contributed greatly to the insanity in this country and around the world really today, because I haven't studied laws from other countries, but just listening to the news and stuff, it seems like it's basically all the same in most of at least the more wealthier countries. So this is another video on abstracts and why it's important to not allow the government to pin us down to concrete conversations or concrete written down things in their abstract laws or their abstract forms. So we need to really hold them accountable to these abstracts and not allowing them to force us into a system where we have to live by someone else's concept of reality, if that makes sense. Okay, so with that, please consider liking, sharing, subscribing, hitting the bell notification, leave comments in the comment section. I try to make some sort of statement on all of them. And I'll see you in the future.